Sorry, Mr. Edinburgh, I seem to have...
Screen issue.
They seem to be cooking, if not with gas at least.
That takes a few more seconds to come on, so it should be okay.
Okay, well, you fire away.
Sure,
See
Mark.
if we can get this working at some point. We may have to get it tomorrow. Yeah. Okay. All right. Yes, you go. Keep on going.
Right. My lord, just before the short adjournment, I went through the facts of the case of Blomquist, both in the Supreme Court, the National Supreme Court, and also the Court of Justice. And in my submission, it was fairly clear that the sale had been concluded abroad and that Mr. Blomquist was acting in a personal capacity. And we say that the decision is perfectly straightforward. It's not troubling, as the judge below described it in paragraph 128 of the judgment. And further, he seems to have, in essence, misunderstood the way in which it went. You saw that the last paragraph to which I drew your lordship's attention was that the order of events was to ascertain whether there was an infringement of an intellectual property right, in this particular case a trademark, and that occurred because of the double identity test. And then, once one has an infringement of the intellectual property right, you can then invoke the customs procedure. And the whole question really before the court was whether there was an infringement or not, and in particular whether or not there was use in the course of trade. That was the critical point. However, in paragraph 138 of the judgment at page 105, this is in the core bundle, the judge said CJEU was only really interpreting customs regulation so as to allow the authorities to destroy counterfeit goods that have been sold to
So you're going to have to give me that page again.
Of course, page 105, my lord. Core bundle, tab 5.
Oh, in course, sorry.
And paragraph 138.
Oh, sorry, in the judgment.
In the judgment, my lord, yes.
138. Did you say?
138, paragraph 138, yes, my lord.
Well, it's worse than that, because the paragraph starts with the sentence, there is no analysis of the seller's alleged use of the sign in the course of trade within the EU, whereas that's what it's all about.
That's exactly what I was just going to come and say, my lord, but I'm grateful for you to say it on my behalf, so to speak. That's it. We say the whole case was about use in the course of trade. And without that, without achieving that, excuse me, you could never get to the customs regulation. There's no problem with the customs regulation. Once you have an infringement, you then just follow the normal procedure, which in this case was seizure and destruction without compensation.
Well, did you not tell him that?
My lord, yes, but possibly not quite so forthrightly. So, my lord, there's that. And then if you move forward in the judgment to paragraph 145, page 107, the judge says that the real basis of the decision in Blomquist in the Court of Justice must be that either the sale of the counterfeit watch was considered to have taken place in Denmark,
When that's the exact opposite of what the court actually says, yes.
and, if I may add a word, that if that were the case, there would have been no need for a reference. Because if there were a sale within Denmark, that is so act clair that nobody would send a reference off to the Court of Justice. And if there were such a reference, the court would have disposed of it with a reasoned order. And so therefore, that cannot have been one of the two hypothetical bases for the decision. And the second that is put forward is that or that in some way it was intended, that is the watch, to be put on sale in the EU. Well, again, we say from the facts of the case that cannot be right, because it is repeatedly said that Mr. Blomqvist was acting in his personal capacity. There was never any suggestion that he was taking the watch on behalf of somebody else, or that he himself intended to sell it. It was his personal...
He bought it for his own use?
Yes, my lord.
So far as one knows.
As far as one knows, and as far as it's recited on several occasions within the judgment. And so therefore, that way, so to speak, those two ways of avoiding the consequences of Blomqvist, we say were wrong. And because he decided to sidestep it in that way, he did not apply it to the facts of this case. And we say the case is quite straightforward. There's not very many facts. It's not a very long judgment. Neither judgments are very long in the case. Facts are clear, and the consequences are clear. And that the way in which it works is that the act is the sale. So that's the wrongful act. And the way in which jurisdiction can be exercised by the national court is because that sale is to a resident within the member state. And that's the link, and that's why you get the use within the EU. My lord, shall I stop for a moment?
Well, I am listening.
I realise, but...
I am also incredibly frustrated because it means that half the documents I've got I can't see because the screen is somehow not getting a signal. Maybe just disconnecting it will be. Well, I think I've just got to live with it. Just let me try once again. No, it's not having it, I'm afraid. You carry on, I'm fine. I will ignore it.
So I reached the point whereby, in my submission, the judge decided on two false bases, not to use Blomqvist to support the proposition that I was advocating that he did support, namely that a sale outside of the EU to somebody within the EU is an infringing act. And that's as far as I need to go, and it's important because it's in that way that you can catch other wrongful acts, we say. Now,
Excuse me, can you explain what you mean by that?
sorry if
Can
I
you
asked
explain what you mean by that?
other
Catching other wrongful acts.
a wrongful act, namely a sale, as opposed to, for example, an advert or something like that.
Right.
Because if we go to, for example, the judgment to which my Lord Justice Arnold drew attention drew counsel's attention to, namely the Walton case.
Do we have that in the Bible?
You have that in the Supplementary Authorities bundle. So your lordships have that. You have hard copies, I've been told. Oh, do not. Sorry. You only have soft copies. Sorry, you only have soft copies, I understand.
I haven't been sent any copy, but I've downloaded one myself.
If I could have a hard copy, that would be appreciated.
I don't want it. Not for me.
Oh, right. Two. Or just
2. I just the third one. Yeah, it's gone to sleep. No, I've done that. Oh, yours has just come on.
Well, it will come on if you do round the back.
No, I did that and then it came back on and then it went back off saying it didn't have any. It's on, you see. Technology to which I'm unfortunately irrevocably committed, Steve. But
the only part I wish to refer your Lordship's attention was paragraph 163. The reason why this is apposite in this case is because what happened there was it was held by my Lord Justice Arnold that the advertisements and offers for sale made by the global eShop and the AliExpress store were not targeted at the UK or other countries in the EU, but the actual sales were. And that is what I mean, my Lord Justice Arnold, by other acts, because if you're not
So for those who are not familiar with the case, the sales figures in question are set out in paragraph 156. That's the AliExpress store, and then for the global website, it's 139.
Is it paragraph 145 as well, or is it just 163?
Yes, my Lord. So 144 is the consideration of the advert, and 145 is the consideration of the sale. What happened here, in very brief summary, is that the adverts in essence weren't directed or targeted at those people within the EU, in essence because the adverts were targeted at people in the core markets. And the core markets you can ascertain from actually it's paragraph 1 of the decision are Asia, Australasia and the Middle East. So we say in this case, the judge was simply wrong not to apply Blomqvist to the sales that had occurred in this case. Unless my lords have any question on that, I was intending to move on.
please.
And so therefore the third ground of appeal is the one on importation. And the judge deals with this at paragraphs 190 to 193 of the judgment. And what we say here is that the judge, in essence, his understanding of the term importation was incorrect. Because you can see from paragraph 191, which is at page 119 of the bundle, that quite apart from the fact that the importation in this case is by a private individual who is not infringing the trademark owner's rights, the defendants could only be liable for importing the goods if they thereby intended to put the goods into free circulation in the EU. There was no such intention on the part of any of the defendants, as their only intention was to fulfill and deliver the order made by a private consumer in the UK-EU. That seems to equate importation with some act of importing plus an intention to put the goods into free circulation in the EU. my submission, that's incorrect, because importation should be understood as entering the jurisdiction, clearing customs, and once it has cleared customs, those goods are then in free circulation. There's no need for an intention. It is the natural consequence of them clearing customs, which means that they are in free circulation. So there's that which we say is wrong. And then further,
What does he mean in 190 that the consumer is the importer of record? So I asked you this morning about who the importer would be in a case where there was a consignor used, as my Lord Justice Arnold said. Do you criticise the judge at the beginning of 190?
no, my lord, because in the terms of condition, the way in which it's set up is the ultimate consumer is described as the importer of record. So theirs is the name that goes on the document as it goes through customs. But in my submission, it's irrelevant because the actual entity that does the importation is the consignor, and that they are acting in the course of business.
Yeah. So you say the importer of record is what, not relevant for your current argument, whatever of record means.
Exactly.
Yeah. Yeah.
It's just simply.
So is there a finding or alternatively evidence as to who the consignor was?
It's an entity that's engaged by D2, for example.
I mean, as I understand it, Amazon basically has the choice of who to engage to ship the goods.
Correct. Yeah. So what happens, as I'm sure you're aware, is in essence the consumer purchases something upon say.com, and then you've signed up the terms and conditions, and if you've asked for importation, it is then Amazon that arranges for the importation through a commercial carrier.
So as I understand, you're relying in essence on what he says at 185, is this correct? Where he says the sale takes place in the US, title to the goods, risk of loss passed to the customer on delivery is the carrier in the US. Customer deemed to be importer, potentially liable. However, despite the allocation of responsibility, it is Amazon that makes all the arrangements with the carrier to transport the goods into the UK/EU. So, do I understand from what you've just submitted, that's what you're relying upon?
Yes, ma'am.
So how do you put it? Which is the importer? Is it the carrier or is it Amazon?
Well, the physical importer is the carrier,
Right.
and so that's the act. But then I'll develop this under the following
So why
ground.
is Amazon doing the importing?
Well, it's because they are acting, we say, to a common design with the importer.
Right. So this is joint liability point.
My lord, yes. There are many different divisions of Amazon. So, for example, there's a payment division and what have you. But there does not seem to be an actual courier division.
The courier is a third party.
Yes, my lord, acting in the course of trade.
Yeah.
Well, can I just ask a question about that? Because, as is often the case with these things, it depends which end of the telescope you look at it from. So, undoubtedly, it's Amazon that's making the arrangements to export the goods from the US. But does it follow necessarily that they are jointly liable for importation into the UK?
Well, we would say yes, and that is because if you follow the entire chain from the very first advert through to the actual delivery with the final consumer, Amazon is standing behind each and every step. So I can give you an example of that. In the supplementary bundle, tab 1C, page 84, the courier is UPS. But what happened here was that there was late delivery. And it is not UPS writing this, but Amazon. We're very sorry your delivery is late. Most late packages arrive in a day. If you have not received your package by tomorrow, you can come back here the next day for a refund or a replacement. And so, my Lord, Lord Justice Arnold, this takes us further than the export to the import, to the very fine. They're even going further than the import. They're going to the actual delivery into the hands of the final consumer.
Is that the same? Is the same offer made in relation to purchases through another route, not when it's fulfilled by a third party? Because as I understood it, the contract said that property passes and basically you, the customer, are responsible. That's it.
My Lord, the statement you've just uttered relates to this transaction fulfilled by merchant. I think this is fulfilled by this. Yeah. So there's a cascade, and with respect to fulfilled by merchant, Amazon up front wash their hands of any responsibility. But even so, they might not be liable according to their terms and conditions. They're still sending out this message to the final recipient.
Well, even leaving aside the fulfilled by merchant case, I mean, let's go back to the more ordinary case. Let's say it's fulfilled by Amazon or one of the other models. So the judge's analysis, as I understand it, is that under the contract between the purchaser and Amazon, it states very clearly that the importation is by the customer. And true it is that the customer has no contract directly with UPS, who is actually carrying out the physical activity. UPS is engaged by Amazon, but nevertheless, says the judge, it follows from the contractual arrangements between the customer and Amazon that the importation is being carried out by UPS on behalf of the customer.
But it's all arranged by Amazon. And Amazon's involvement is absolutely integral to the whole importation process. For example, with respect to the importation duty.
That's the joint tortfeasorship point, and I understand that. But one has to start with the question of who is primarily liable for the act of importation. And
yes.
the judge's reasoning, as I understand it, is the question of joint tortfeasorship didn't really arise because the customer was the person who was liable for the act of importation, and the customer wasn't doing it in the course of trade. Therefore, there was no joint liability on the part of Amazon. So one needs to start with the act of importation and who is legally liable for the act of importation.
Yes. In that case, the UPS, consignment, is acting in the course of trade.
Well, it is, as a carrier.
Yes.
It's pursuant, it doesn't do it off its own bat. It does it pursuant to contractual arrangement.
Yes. But point is that importation is a separate act of infringement, and you don't have to own the goods in order for the act of importation to occur. So the fact that UPS is importing goods over which it has no title is irrelevant.
So let me see if I've understood this correctly. Your submission is that here, in this example, the importer is the entity physically bringing the goods into the United Kingdom. That is UPS. You say the fact that UPS has no title is irrelevant, and the fact that it's done pursuant to contract with Amazon is equally irrelevant to that question, but is relevant at a later stage. Is that your submission?
My lord, yes. And I can give you a reference for the title point. It's in the UDV case, paragraph 51. My lord, you can see the role of D2 in this at page 147 in the supplementary bundle, behind tab 1D, at the bottom. By placing your order, you authorise Amazon Export Sales LLC, that's D2, or the merchant who is listed as the seller of your product as applicable to designate a carrier to clear the package and pay the import fees.
Right.
And this is with an Amazon export business model.
So why does that not support the judge's analysis that by virtue of the contractual arrangements, the customer is authorising Amazon, or specifically Amazon Export Sales LLC, to designate a carrier to bring the goods into the United Kingdom?
Sorry, I think I misunderstood your question, but the point being is that Amazon is engaging the carrier.
But it does so to act as, I mean, if you go 2 pages further forward to 149 under the International Shipping Terms and Conditions,
Yes.
you get a slightly fuller exposition of what you just showed us in the 3rd paragraph, don't you? You authorise Amazon Export or the merchant as applicable to designate a carrier to act as your agent. So it's authorising Amazon, etc., to instruct somebody on behalf of the customer.
Yes.
So Amazon. So where does Amazon actually feature in this, other than as agent?
Right, I think we're talking across purposes. Because what I was trying to establish was that the importation is done in the course of business by the carrier.
So your submission depends on distinguishing in the way that the judge does not between who does the physical act,
Yes.
and the contractual arrangements pursuant to which it is done. You say that for the purposes of the infringement case based upon importation, it's all about who does the physical act and whether they do it in the course of trade.
Yes.
A physical act in our example here is done by UPS.
Yes.
They plainly do it in the course of trade because that's their business. And you say contract is only relevant to the allocation of liability.
In essence, yes. And you see, I mean, this touches upon the rotor crop point, which is a joint tortfeasorship with a party that's not a tortfeasor. Now,
Well, why? Because if you're right so far, I say if, then that doesn't arise because you've got someone who's primarily liable acting in the course of trade viz UPS.
yes, well, yes, that's how I put my case. But one of the arguments that's put against me is that because the consumer, the ultimate consumer, is acting personally, there can be, in essence, no joint tortfeasors. But you see, in my submission, that just misses the point. Because it is, as my Lordship, Lord Justice Arnold has just said, it's the consignor, UPS, who's acting in the course of business.
Well, your point is that Amazon is a joint tortfeasor with UBS, not with the consumer.
Yes, my Lord. Because I think I'd be in difficulties arguing, even though this takes me slightly out of order, that one is a joint tortfeasor with a party, well, when there's no tort.
But the judge seems to have misunderstood that as your point.
My Lord. My Lord, while we're in this bundle, might I just draw your attentions to the point that I made earlier to make good? It's page 138. This is about the import fees. Because the way in which this works, you'll have seen from some of the documents you've already seen that if you order from the US and it's coming to the UK, there's going to be not only delivery fees, as is obvious, but there's going to be import fees of some sort. And the way in which it works is that those import fees are calculated, or rather an estimate is put forward, and that estimate is added to the bill. And if that estimate is wrong, then what happens is that Amazon, and you can deduce this from the verbiage at page 138, that estimate is wrong and the customer has paid too much by way of estimated importation fees, then the excess is refunded to the customer. But if the estimate is wrong in the other direction and the estimate was too low, then Amazon cover the excess.
Is that just for global store, or is that also for one of the other methods as
It's
well?
3 out of 4, so it's not the fulfilled by merchant. The fulfilled by merchant has the lowest involvement of Amazon.
Is that something different from Amazon Marketplace?
I don't know the answer to your Lordship's question, I'm sorry.
Well, I'm just looking at the text you just asked us to look at. It says you won't be charged additional fees if the actual import fees exceed the import fees deposit we estimated.
Yes, yes.
For items sold by Amazon Marketplace sellers, please check the seller's policy.
Yeah, that's the fulfilled by merchant.
Right, so it is
Sorry,
the same,
yes.
yeah.
Yeah, sorry.
Okay.
At this stage, it's probably sensible to go to rotocrop. You'll find that in the authorities bundle behind tab 1. What happened here was it was a patent infringement matter brought shortly after the introduction of the new Act. And the product could only be infringed if it was assembled and compost was actually made. It was to do with the garden compost system. And what happened was the defendant, the corporate defendant, sold the parts such that the client, the customer, would assemble the parts and make compost. And on page 259 of the judgment, which is actually page 20 of the authorities bundle, you can see the way in which the judge put it, halfway down the first paragraph. Here the defendants are joint tortfeasors with Miss Harris, who admittedly bought a kit of parts for a bin from the defendants, and it is a proper inference that she made it up. It is not a fact positively proved that she made compost in it. However, it is quite clear from the advertisements that the defendants invited their customers to make bins from the kits they sold and to use them for making a compost. It is a fair inference that at least some of them did so, and the defendants knew quite well that they would do so as alleged in the particulars of infringement. Same applies to Miss Harris. That being so, I find the defendants to be joint tortfeasors with their customers. I'm including Miss Harris in infringing claim 6. Now, the reason why that case is slightly difficult is that Miss Harris was obviously acted in her personal capacity when she made up the compost bin and made compost in it. And there's a defence in the Patents Act under section 60 subsection 5 whereby liability...
The point is nowhere addressed in the judgment.
Exactly. Whereby the defendant would have a personal defence. But as Lord Justice Arnold has pointed out, I mean, it's very clear that that subsection of the Patents Act is not addressed.
So how does this help?
So, well, the point being is this case was raised below, and therefore I felt I needed to deal with it because it sort of led to some confusion in the sense that the way in which I put this case with respect to joint tortfeasors, and so this is moving slightly into the next rounds of appeal, is that you can be a joint tortfeasor with a person who would commit a tort even if they would have a personal defence that is applicable to their particular circumstances.
How does that square your concession with your concession a minute or two ago that you can't have joint tortfeasance if there's no tort?
Well, because there are different scenarios. Because the first scenario is there is a tort, but there is a defence. The second scenario is there's no tort in the first place.
How do you have a tort if there's a defence to it?
Well, because if you don't invoke the defence as a completed tort, the defence is to the completed tort, as outlined in the Act, whatever Act it might be. But if you don't have all of the elements necessary to complete the tort, then there is no tort. What happens here would be there are all the elements to complete the tort, but then there's a defence, which excuses liability.
And what's the defence?
In this particular case, it's one that was not run, which was under section 60, subsection 5, paragraph A, that a person acting in their personal capacity is excused liability from patent infringement. And this has a particular reference to the way in which certain cases referred to in the Sea Shepherd case. So what I was proposing...
I'm a little puzzled by this, because the way you were putting the joint visa case on importation, this point doesn't arise.
No, exactly, but it did arise in the judgment, so, and because it also sways into the point about...
Are you saying it's relevant to some of your later grounds?
Well, it's the analysis is relevant.
All right.
So that then brings me, in essence, to grounds 4 to 6, unless I've got any further questions to field with respect to the importation. So grounds 4 to 6 have been taken together. You see they've been taken together in the Claimants skeleton before you. And the law is set out in the Sea Shepherd case, which is authority 7, starting at page 187. My lords, I was intending to take you through the law fairly quickly on this, because I don't think it's in dispute. But it's the judgment from Lord Justice Sumption, sorry, not Lord Justice, Lord Sumption, that starts at 37, page 200 of the authorities bundle, where this starts to become relevant. So he sets out the general proposition in paragraph 37. And then moving to 38, he quotes from Lord Neuberger in the Vestergaard case. And this is a difficult decision. The Vestergaard case concerned an infringement. Well, it wasn't really an infringement, it was an equitable wrong, because it was the misuse of confidential information. And what happened in the appeal to the Supreme Court was that the sixth defendant could not be a joint tortfeasor with the other tortfeasors, because she lacked the necessary mental element to have committed the tort of wrongfully using confidential information. And the quote that is contained of that case within the Sea Shepherd case reads as follows: in order for a defendant to be a party to a common design, she must share with the other party or parties to the design each of the features of the design which make it wrongful, if and only if all those features are shared. The fact that some parties to the common design did only some of the relevant acts, while others did only some of the other relevant acts, will not stop them all from being jointly liable. Now, the reason why the sixth defendant in the Vestergaard case was not liable was because, as I said, she didn't have the necessary mental element. She didn't know that she was misusing confidential information, and therefore her conscience wasn't touched, and therefore she committed no wrong. But this type of case is completely different, because there's no mental element to the wrong that we say is being committed. And so therefore, that reliance upon you need each and every one of the features of the design to make it wrongful is misleading in a case of this sort, because all you're talking about is various acts. And as that quote makes clear, it's perfectly possible for the various actors in a joint tortfeasance case to commit different acts themselves, so long as none of those actions are de minimis. Then, if they're working to a common design, you get joint tortfeasance up and running. Now, to make good that point about de minimis, if you go to the judgment of Lord Neuberger, which starts at, substantially starts at paragraph 55 on page 206, he repeats the three-part nature of the tort. The defendant must have assisted the commission of an act by the primary tortfeasor. Secondly, the assistance must have been pursuant to a common design. And thirdly, the act must constitute a tort. And then when he talks about the first requirement on paragraph 57, so far as the first condition is concerned, the assistance provided by the defendant must be substantial in the sense of not being de minimis or trivial. However, the defendant may not escape liability simply because his assistance was relatively minor in terms of its contribution, or indirect insofar as any consequential damage to the claimant is concerned. So you'll recall that what happened in the Sea Shepherd case was actually two of the law lords in essence held that the assistance was not de minimis. Three of them held it was de minimis. And so there was a split vote on that point. But they are all aligned with respect to the three elements of how joint tortfeasance can come about. And what we say here is that there is a wrong, so the third condition, assuming you're with me on other points, there is a wrong, so the third condition has been satisfied. Then you need to see what roles are being played by the different parties, and so long as those roles are not de minimis, then that's sufficient to give rise to liability. And then you have to see whether it's pursuant to a common design. And with respect to the common design, at paragraph 59, Lord Neuberger said, common design will normally be expressly communicated between the defendant and the other person, but it can be inferred. So sometimes you can just see what is being done. And in my submission, it is then right to say that you can infer that there has been a common design. There's no need for the parties to know that what they are doing leads to a tort. It's just that they have to act together to commit the act, which turns out to be a tort. Now, the way in which we put this, and this all appertains to the role of D3, is that their role is central to what was happening with respect to the commission of the final torts.
Can you enlighten me as to why this matters if you succeed on your other points? Because you seem to have before the court all relevant Amazon entities, and if some of the other entities are liable, D3 isn't, so what?
Well, my lord, it is partly a belt and braces operation, yes, but it's not entirely that. And the reason is because it's sometimes difficult to pin down who does what. And so therefore, the claimant's solution to that problem was to go for somebody further up the chain. As opposed to each individual actor, you try and get the person who is organising the actors, so that if there is any mishap in identifying any particular party for any particular act, you get somebody who has been, in essence, directed.
Yeah, but usually when you're going after the spider in the web, you're doing so either because you're concerned about jurisdictional limitations against some of the bit part players, or because you're concerned that relief against the bit part players will be ineffective.
Well,
do either of those apply here?
Broadly, no. I mean, Amazon is good for the money, whichever bit, unless you're incredibly unlucky, you aim at. And with respect to jurisdiction, there's parties everywhere. But the point is that as I said, it's a belt and braces approach. We don't say there's anything wrong in being careful in making sure that we capture the person, the entity that is organising what we say are the wrongful acts. And we say D3 is central to the whole thing. I might show you if you go to the supplementary bundle 1C, page 54, and page 54, the relevant point here is the copyright notice right at the bottom. Copyright 1996 to 2020, Amazon.com Inc. That's D3. And so here, D3 is claiming to be the owner of the copyright. And you'll also see there's two other links there, conditions of use and privacy notice. If you click on conditions of use, you come to the document at page 60. Conditions of use. First paragraph says, welcome to Amazon.com. Amazon.com Services LLC and or its affiliates, Amazon, provide website features and other products and services to you when you visit or shop with Amazon.com. Use Amazon products or services, use Amazon applications for mobile, or use software provided by Amazon in connection with any of the foregoing, collectively Amazon services. And then if you go down to copyright, all content included in or made available through any Amazon service, such as text, graphics, logos, button icons, images, audio clips, digital downloads, data compilation, and software, is the property of Amazon or its content suppliers. Now, because of the copyright notice that's on page 54, and because of the way in which Amazon is defined in the first paragraph, Amazon.com Services LLC and or its affiliates is Amazon, we know that with respect to the copyright that is used for the Amazon services, it's Amazon.com Inc. So D3 is the copyright owner, and therefore its permission, its active involvement, its direct control must be needed for the use of those Amazon services. So it's absolutely integral. D3's permission must be absolutely integral to the operation of the Amazon services And those Amazon services are those that you get, in essence, on Amazon.com. And so that way is using the language that we started off with when we were looking at the first ground, whether there was direct control, whether there was an active involvement. We say that D3 is thereby brought into the operation of .com directly. And then, if you go further on in conditions of use to page 62, right at the bottom, it says our address. So that's got to be Amazon's address as per the opening paragraph. And that address is Amazon.com Inc., which is D3. So again, it's D3 who is, in essence, responsible for these conditions of use and also the implementation and use of all the copyright. And furthermore, the other notice that you can click through to, the privacy notice.
Well, just before you get there, are you relying on page 63? How to serve a legal process is also Amazon.com Inc.
Well, it is also there.
Notice for making claims of IP infringement. It's the Amazon.com legal department. That's same address.
Yes.
As at page 62.
Yeah. I mean, yes, my lord, I am, but there's, so to speak, in my submission, lesser matters. But they are still there. And the reason why it could be a lesser matter is that it could be a passive thing to receive a complaint about IP.
Yep.
But it cannot be a passive matter to grant permission to use the copyright protected works. There has to be a license, be it express or implicit. My lords, I was then going to take you to the privacy notice, which is on page 55. The long and the short of this is how Amazon communicates with its consumers about what sort of data they collect and what purposes they put that data to and so forth. But for my purposes, it's on page 57 that's relevant under the EU-US and Swiss-US Privacy Shield. It's Amazon.com Inc., that's D3, participates in the EU-US and Swiss-US Privacy Shield frameworks.
Those are the ones, no doubt, that were held invalid in Schrems 1 and Schrems 2. But yes, go on. That's by the by.
My lord. But the point being is that this whole system, regardless of how good the software is and regardless of how good all the interface is, does not work unless you have personal data. And the personal data, the person that's is responsible for that is D3. Their name is on this document. And the whole system doesn't work without personal data and movement of personal data. So the personal data obviously includes your name, but it would also, sensitive data would include things like your credit card details, for example. And as you well know, the EU is quite sensitive about the way in which data is handled. And so it's essential that this is handled properly. A party has to take control of it and hand it out, so to speak, appropriately. But all the way through the transactions, your personal data is being used. So when you log on, and if you've registered them with them before, it will bring up such things as where you live, and also probably your credit card details if that's been stored. But when you get it delivered, when you get something delivered to you, it must also contain your name and address and things like that. And all this sort of information has to go through to every stage of the transaction because otherwise the branded goods can never reach you. And so it's for those three reasons, principally, the copyright notice, which ties you to the conditions of use, which ties you further then to the privacy notice, but we say that D3 is intimately involved in the operation of .com. Now, it might be a different entity, and this addresses my Lord Justice Arnold's point, that is responsible, so to speak, for the maintenance of the .com site, but that different entity could not perform its function without a license from D3 to use all the software, all the copyright protected software and forms and what have you. Wherever you see a form, wherever you see a page, you'll see a copyright notice with Amazon's name at the bottom. Now, we say the judge just did not address this. The closest he came was paragraph 201 of the judgment. Where he mentions conditions of use and the copyright point. But he doesn't address the privacy notice point, and so therefore the use of personal data. And he doesn't address the point that if you're the owner of the copyright, you must thereby be the person who's giving permission for the use of all that copyright protected material.
So we held at 203 that, as a matter of fact, that the operator of the website is not the third defendant, but one of its many subsidiaries.
My Lord, yes, and that Amazon.com Services LLC is the name that you saw on the conditions of use, where it said, if you want me to go back to it, that or its affiliates, open parentheses, Amazon, close parentheses. And then when you scroll down, so to speak, to the copyright point, you could see actually that it was D3 that was the owner of the copyright, as shown by the fact that it claimed to be the owner of the copyright in that copyright notice to which I drew your Lordship's attention.
So you've appealed the finding, have you, that
No.
you've sued the wrong person?
No, my Lord, you see, that's exactly the point. It's not that we sued the wrong person. This entity might well be another wrongdoer. But it's to address my Lord Justice Arnold's point about why do we need D3 when we've got D2 and D4 already. It's because of this sort of point that we don't want to go around suing hundreds upon hundreds of Amazon entities when there's 2,477 according to the Dun & Bradstreet company report. We can short circuit that by getting D3, and D3's central involvement, if caught, would necessarily stop Amazon.com Services LLC. And I've already shown you how Amazon sort of operates as an undifferentiated whole when I responded to a question from my Lord Justice Snowden about the guarantee with UPS. because at that stage, the whole thing had gone wrong, in essence, in this country, in the UK. And yet it was Amazon who was writing to the customer, saying, if something's gone wrong, come back to us. Not come back to UPS. It's cradle to grave, so to speak. It's from the very beginning to the very end.
Yeah, but that goes to liability as between Amazon on the one hand and UPS on the other hand.
Yes.
Whereas here you're concentrating on liability of D3. So how does that help you on liability of D3?
Because the only way in which UPS could have got the customer data is by D3 through the EU-US Privacy Shield transferring that data.
Well, I don't follow that. I mean, the Privacy Shield is all about data moving outside the EU, and in this case, to the US. But if you're talking about EU consumers, why do we need to suppose the data goes outside the EU?
Because it must have come from the consumer to the .com site.
Well, that depends on who's operating under the relevant business model, doesn't it?
No, because...
Well, take the case where you got fulfilled by merchant.
Yes, my lord.
Why do we necessarily suppose the consumer's personal data is going outside the EU?
Because the EU consumer has interacted with the .com site where the third-party merchant is advertising its goods.
Yeah.
And so it's not the merchant that is the recipient of that data initially. It must be .com operator. That is controlled, in essence, we say, by D3.
You seem to be assuming what you're trying to prove there. I mean, I can understand the proposition that says the whole thing can't operate when you're talking about goods coming from the US without the operator of the .com website being involved. I get that. But then the next question is, well, who operates the .com website?
And according to the conditions of use, it was Amazon.com Services LLC.
And that's the judge's point.
Yes,
isn't it?
yes, but, my lord, the conditions of use then define the operator as Amazon.com Services LLC or its associates, and then as an umbrella term, Amazon. And then when you look, that it's Amazon that is providing the Amazon services. Then when you look at the copyright notice with respect to the Amazon services, the copyright entry with respect to the Amazon services, we know that it must be D3 that's the owner of the copyright, that's underlying
Right.
all.
So am I just being slow in getting to the same answer that you gave to my lord earlier? Namely, you don't dispute the finding that Amazon.com Services LLC was the operator of the website. You say that's not the end of the inquiry because D3 is jointly liable for that.
Yes. It's because of the intimate involvement of D3 in every single aspect of the .com site that we say it is involved. And that addresses your earlier point, my lord, about whether we sued the wrong defendant or not. We say we could have sued Amazon.com Services LLC, but that's a never-ending whack-a-mole problem. And actually, within the course of this dispute, the actual operator of .com changed in any event. It's simpler to go to the party that is controlling everything.
How do you deal with paragraph 205 of the judge's judgment?
Well, my submission, it does not just disrespect the corporate structure. Quite the opposite,
There's no
actually.
evidence of any common design, only be liable if it were pleaded and proved that sufficient assistance pursuant to a common design was provided by the third defendant.
Well, we say that
Finding
it's
a fact.
perfectly proper to infer that there is a common design.
Where's your ground of appeal here? In the core bundle?
Yeah, page 13. Rounds 4 to 6. So, my lords, in essence, that's what I was going to say on those three grounds rolled up together. In which case,
Yep.
then, I'll move on to the last ground.
Mm-hmm.
This is a completely different point, really. It all stems from the fact that the judge considered that the damages were, in essence, low thousands of US dollars, and that therefore it would have been inappropriate to order an inquiry.
Now, on this question, I have a question which is not directed just at you, but also those on the other side of the court as well, which is, since when did it cease to be the duty of counsel to draw to the court relevant authorities? Because, to my knowledge, there are at least two decisions of this court which are directly on point on this issue, not cited by either side in their skeleton arguments. How come?
Well, I'll take full responsibility that we must have missed them.
They're in Curly. They're not hard to find.
No, my lord. Well, possibly because we thought it was such a blindingly obvious point. But
That
that
appear to be blindingly obvious to the judge,
No, my
perhaps
lord.
because he wasn't taken to the relevant authorities.
my lord,
So let's be clear. The two I've got in mind, which are the leading authorities, are firstly, in time, Burger King and McDonald's. McDonald's and Burger King, let's get them the right way around. And secondly, Reed and Reed. I take it that the judge wasn't taken to either of those authorities either.
that's correct.
So it's not surprising he fell into error, is it?
My lord, I apologise.
Right. Now, next question. I assume that it wasn't pointed out to the judge that a possible alternative course was to take the middle way of summarily assessing the damages.
That was not pointed out to him, and we would have resisted such an attempt.
I don't doubt it.
Yeah, but that's my answer, my lord.
Right. Okay. Fine. So, where do we go from here?
Well, there's a third point, my lord, and that is you could invoke the barrel jurisdiction against me on the grounds that until the order's signed off, he's allowed to change his mind. But there comes a point where you've put in some evidence, you've made some arguments, and you just have to accept what he's decided. And that's what we did. We put in evidence, prima facie evidence that was unchallenged, that with respect to the admitted adverts, so it's not got nothing to do with whether any of the other arguments that I have succeed. It is that with respect to those, the damage to the claimant's business amounted substantially more than the value, in essence, of the actual sale. Now, that was a submission that we made and we supported with prima facie evidence.
So, what evidence is that, please?
it was the evidence of one of the licensees that the reason they weren't taking licenses, you'll find this actually, just 1 second.
This is something else that I can't find it referred to in your skeleton argument.
It's in the RFIs.
So I'm a bit puzzled, Mr. Edinburgh, forgive me, but in paragraph 59 of your skeleton argument, you complain that the judge deprived you of the opportunity of finding any evidence on the issue, whereas now you're submitting that actually there was evidence.
Well, sorry. It goes to 2 points. There was prima facie evidence, which was unchallenged. But the way in which you put it in the skeleton is that if there had been an inquiry, we would have bolstered that evidence.
Well, inevitably, if there'd been an
Yes,
inquiry,
yes.
there would have been evidence from both sides.
Yes.
That's the whole point of the
Yes.
inquiry.
But there is prima facie evidence.
All right, so where do we find that?
In tab 11, and its response 7. And 8. And 9.
This is the pleading, right?
Yes, my lord.
Yeah.
But it was then substantiated with evidence.
It was.
Well, it's got a statement of truth on it, so
Yeah.
it's evidence to that extent anyway.
Not admissible.
So the point being is that the judge took the view that the total damages were going to be low thousands of US dollars, and it wasn't therefore appropriate to order an inquiry. But there was unchallenged evidence before him that on the admitted omissions, the damage would be higher. Now, whether we make good that, the inquiry, is a separate issue.
Yeah, well, it's the usual story. It's you proceed with the inquiry at your own risk as to costs. I understand that solution. But the test is whether there's a realistic likelihood of substantial damages being incurred. That's what we get from the authorities. But then nowadays, one also has to overlay that with a proportionality analysis.
My lord, yes. But the contention that was put forward in an unchallenged way was that the damages, the potential damages, would be significant. We're not talking going from, for example, 5,000 US to 10,000 US. We're talking clearly 6 figures, if not 7 figures.
Sorry, I'm struggling as to where these numbers are coming from. I mean,
It's the evidence from these licensees.
well, but it is all we've got what's in the RFI,
No, there was a witness statement as well.
and that gave numbers to it.
I'm checking that, my lord. Right. Nobody behind me can remember, and I can't remember expressly, but there was a witness statement to the effect that the damages would be non-trivial.
Well, I think you need to bottom that out, because if there was a witness statement before the judge from a witness who was called, that's important.
No, he wasn't called. He wasn't called.
Or was he not? Was cross-examination not required?
I mean, putting the law aside, it's a little difficult to criticise the judge for not having regard to things he wasn't actually referred to.
Well, yes, but sorry, my lord, that would be right. But this was raised in the skeletons below.
And I mean, was his attention drawn to on this point? Was he told that the damages could run into 6 figures? We have evidence to back that up.
I mean, what he said is it would be wholly disproportionate to order an inquiry as to damages flowing from pre-2019 infringements. That's what he said.
Yes, my lord. And that's because he formed the view that the case was about, in essence, mere visibility. And so he didn't accept the claimant's argument that there was a problem with respect to EU consumers seeing the price of US branded goods.
Well, I still don't understand that argument, I'm afraid, Mr. Edinburgh. You ran into stormy waters this morning with that. Your grounds of appeal are about whether there was an infringement, which you have explained and argued quite clearly. I do not understand an argument based upon why your clients were upset by what Amazon were doing as being relevant to whether or not there was an infringement. Either there was an infringement or there wasn't. And if there were infringements, you are entitled to be compensated for them.
Exactly, my lord. It's the last point. It's the damage that flows from the infringement.
Well, but that may be an argument that you want to run on an inquiry. But the judge decided that the only infringements he'd found were very minor.
Yes.
And that they themselves did not give rise to substantial damages beyond a couple of thousand. And therefore, he said it would be disproportionate to order an inquiry. Now, you may say that's not disproportionate. I should have been entitled to have my 2,000 assessed.
Well, my lord.
And you may also say those damages, those infringements gave rise to massive other damages. You may say that, but I don't understand how you make that good.
Right. It's not the first point. I don't say that we should get an inquiry just to make good a claim for a few $1,000 US.
And you don't say that it should be assessed at $2,000.
Exactly. Because we say, it's the last point, my lord, that we say the factual matrix is you have a potential licensee who is thinking of taking a license from the claimants with respect to selling these goods in the EU. Now, when they do their background, what they want to know is whether they can sell these products at a certain price point. And when they do their research, they will go on to, for example, Amazon and see that US branded goods at a far lower price point.
I know.
Yes, but
I mean, I know. And if you're right that there are continuing multiple infringements for the reasons you've been arguing, this may be a perfectly good point. But it is not a good point if you're looking at isolated infringements in 2017, half a dozen goods, because that did not give rise to this putative licensee refusing to take a license. What gave rise to the putative licensee refusing to take a license was the continuing breaches and the activity of Amazon over many years in doing what you complain about, which, if you succeed on the appeal, may be a very good argument.
But
It's
my
not
lord,
a good argument on what the judge was dealing with at paragraph 209.
but on the admitted admission, on the admitted infringement,
Yeah.
the argument was that the sight of those goods had caused certain potential licensees not to enter into licenses, or to enter into licenses on less favourable terms than they had done historically.
Well, I mean, I didn't see that in the RFI.
Can you just help me as to the procedural context for 209 of the judgment? Because I was just looking at the closing written submissions, and there's not a word on this subject from either side, not one word. So was there any oral argument on this at all?
Well, it was in the judgment, it was before the judge in opening, but not necessarily in closing. Because in essence, the way in which it's put in the IP...
So I'm sorry to interrupt you when
No,
you're in mid-flow, but I'm struggling very much to understand this. Because you're giving me the impression, and I want to be sure that it's well-founded, that 209 came at you out of the blue. Because you've already told us the judge wasn't referred to the relevant authorities, and that's understandable if there was no argument at all. Equally, I'm getting the impression that he wasn't shown the evidence. Again, that's understandable if there was no argument at all. Whereas those points are less understandable if, despite the absence of any written argument, there was oral argument.
Well, there was, in opening, I opened that.
Sorry, you opened what?
I opened the point that there should be an inquiry.
Right.
And that what one had done is we provided prima facie evidence that there should be an inquiry.
And then you say nobody returned to it in closing submissions.
In closing submissions, I don't think anybody did.
I mean, to be fair, in opening it, I mean, you sort of flag it at paragraph 111 of your opening, I think. So it wasn't your opening. Yes, it was your opening, sorry.
I mean, the thing that worries me about this point, but the thing that worries me about this point is if you win the case, I quite understand, if you win the main substantive
Yes,
appeal,
my lord.
I understand that you'll be in a strong position to say you should have different relief. If you don't, at the moment, I can't see how you can really challenge this, except on the basis my lord suggested, which is that you get an assessment of the minor damages you may have suffered. But I don't see how you can say that the judge, having made the findings he found, having made the decision he made, was wrong to say that when he wasn't being asked to assess the damages, that it was disproportionate to have an inquiry. That's
The way in which it normally works in an IP case is that you fight the main trial on liability.
yeah, but if you lose, you don't get an inquiry.
No,
in an IP case.
exactly so, my lord. But we had some admitted infringements.
Yes,
Yeah.
that's what I'm talking about.
Yeah, no, exactly. And the evidence that we put in respect of that was that those admitted infringements would lead to more damage than just the nominal value of the lost sales.
Well, it wasn't really that, was it? It wasn't that the admitted infringements would. It was that the whole situation did.
Well,
And nobody ever said to the judge, even if we lose absolutely every other point, we've still got to have an inquiry as to these massive damages we may have suffered. I mean, I think, you've had a fair run, Mr. Edinburgh.
my lord, I don't need to press it any further.
Thank you.
I was going to say, just for the notes, the only, as I understand it, in the supplemental bundle at page 197 to 198, paragraphs 111 and 112, the way you raised this point
In opening.
in opening,
Yes.
and it was answered in one paragraph at the end, right at the end of Mr. Mellor's skeleton argument at page 274. I mean, that's it. You were both effectively saying we'll deal with it as and when.
Yeah.
And then it doesn't seem to have been dealt with at the end, by the sound of it.
And 112 contains a reference to one Haddad, so I assume that's the witness statement you were referring to earlier.
My lord, yes.
Okay, thank you.
That was the evidence that related to the unfavourable licence terms and lost licence opportunity.
You're 3 minutes over 4 hours.
Yes, I know. My lord, unless you have any further questions for me.
Thank you, Mr. Eden.
My lord.
Nothing else. Thank you, Mr. Alexander.
My lord, I'll deal with the points in the same order. Targeting, which will encompass advertising and offers for sale, although they do need to be dealt with somewhat separately. Then the sales point, then importation, and then joint liability and the way it's put under the various heads, and finally the point on remedies that's just been raised in the procedural issues. My overall submission, as your lordships will gather, is that this is, in some senses, an unimportant case which raises some important issues. It does so under the various heads, some more important than others. In relation to the aspects of alleged trademark infringement, these are matters which potentially have an impact on international commerce, not just in relation to substantial online marketplaces such as Amazon, but also, of course, in relation to other kinds of online presences by undertakings in foreign countries where their goods or services may be accessible in various ways in this.
But if the laws are the law, the law's the law.
The law's the law, the law's law. And I don't want to dwell on those points because from the questions from the court, your lordships are, if I may put it this way, all over the points on this issue. So I'm going to try and just pick out some of the key points of submission on this point. Our overall submission in relation to targeting, advertising and offers for sale is that the judge correctly set out the law and its contours, and I'll come on to the contours, and that he applied it to the facts of the case in a sensible and rational way, having regard in particular to the perceptions of the average consumer and the relevant context that the average consumer would bring to bear with respect to the consumer's encounters of the respective uses that are said to be wrongful uses. In relation to sales, which raises the Blomquist point, and to some extent the Walton and Verveege, I'm not quite sure that's the right pronunciation, point in the case which my Lord Justice Arnold drew to our attention and for which we are grateful, that raises slightly different issues, including issues as to the approach that the Court of Justice took with respect to the customs regulation and the approach that the judge below took to contending that that was not of relevance in the present context.
Would you say he was right? You
My,
haven't filed a respondent's notice.
my Lord, we didn't, and in our
You didn't what? You didn't
file
say
a
you were right?
respondent's notice. No. Because in our submission, the judge was right not to regard it as of significance for deciding this case. If I can come directly to my Lord's question, though, it might be said that it was right in the context in which it was raised. And can I make that good in the following way?
The judge was right in the context in which Blomquist was raised.
The judge was not only right in the context in which Blomquist was raised, but Blomquist was right in the context in which Blomquist was raised, or at least one might say that, for the following reason. And if I can just come to that point directly to answer my Lord's question. Blomquist was, of course, not concerned directly with the question of whether there was a trademark infringement. It was concerned with it indirectly
It had to be
because...
concerned with it because without a trademark infringement, there was no.
Indeed, I'm coming to that. I'm not dodging that. I'm not dodging that point. But if one comes at this from the perspective of interpretation, and in particular purposive interpretation, of a customs regulation, which is intended to provide the power to a customs authority to seize goods that are, if I may put it this way, manifestly counterfeit, and deal with them in an appropriate manner, it might be said that it would be an odd purposive approach from the perspective of the European Court of Justice to treat that regulation as inapplicable in circumstances where the relevant goods in question had come from overseas, unless it was additionally proved that there was, in a sense, a precursor to the sale of those goods overseas, which involved their being specifically targeted at the European, or in this case, United Kingdom market. Against that background, one can certainly see a rationale for that decision being taken in the way it was. And so to that extent, we don't take issue with the approach in Blomquist. Where we do respectfully say that your lordships are faced, as was the judge, with a difficult place to draw the line, is how to address the issue of sales that take place in a foreign country under foreign law, where title and risk to those goods passes in a foreign country, but the purchaser of the relevant goods happens to be in the United Kingdom for the purposes of dealing with the issue of trademark infringement. And I will come on and try and grapple with that point directly, because I suspect it's a point that is uppermost in my Lord's minds in relation to that aspect of the case.
I mean, it's very difficult for me to see how context can affect a point of law.
Oh, my Lord, I'm not seeking to persuade my Lord of that.
It's
at all.
either a trademark, it's either Blomquist either makes a point of law that is law and is binding on us, or it doesn't.
Yes, my point on context was perhaps a slightly different point, which is that when one is evaluating the acts in question of alleged infringement, it is in our submission relevant to consider the appropriate context, and I'll come on to what we say the appropriate context is, in respect of the various acts of infringement that are alleged. And it's perhaps convenient to deal with this, dealing with the targeting aspect first, and then come on to the sales aspect and the Blomquist point. So if I can take that set of issues first of all, and then come on to the sales point. So on targeting, I think ultimately there isn't anything between my learned friend and me that targeting and the concept of direction are relevant concepts for determining, at least in the case of advertisements, and we would respectfully submit as well offers for sale, as my Lord Justice Arnold has indicated in the Walton case, for determining the boundaries between liability and non-liability, or at least liability under English law, EU law, and non-liability where a website or a service has international aspects. That is, as you have seen, a concept that originated in the case law relating to jurisdiction and judgments, the Panna case, which was referred to in the judgment and the subsequent authorities, both Merck and Argos, and has been taken up in the trademarks field as an appropriate approach to determining whether or not there is liability. And we respectfully commend the way in which the learned judge, dealt with the issue, both in terms of the reference he made to the origin of the concept of targeting and the commentary that he added to the case law on that, in particular Merck and Argos. Now, following my Lord Justice Arnold's point about authorities not drawn to his attention, my Lord may say, well, why wasn't Walton among the list of things that were drawn to his attention? And I don't know the answer to that, but I would say, as it were, in defence of the way in which the matter was done and addressed by the court, there had been two authorities of the Court of Appeal, namely in Argos and Merck, which articulated in, we respectfully submit, clear terms, the approach that the court should take and the rationale for the court taking that approach to these matters. And occasionally, just as counsel are criticised for not bringing matters to the court's attention, sometimes counsel are also criticised for trying to cite cases on particular facts that, where there's actually an overriding principle.
Indeed, and Walton was no more than that, and it's easily overlooked because it was on its face a genuine use case.
Indeed.
It's only when you get into it you realise that the genuine use reasoning depends upon an anterior question whether there's targeting.
Indeed, and it's one of those cases which is not necessarily on the infringement
Quite so.
radar for reasons my Lord has articulated, and it deals with matters in a slightly in a way that is sensitive to the fact that it's dealing with that particular context. So if I could then just take up the judge's...
well, but on that question, can I ask you the same question I asked Mr.
Yes.
Reedborough, which is trademark use is trademark use regardless of context, isn't it?
Yes, it is.
Good. And here we're not really concerned with what is trademark use. What we're concerned with is the jurisdictional question.
My Lord is absolutely right, and the only qualification I make to my Lord's general proposition is that determining whether something is or is not trademark use is not always context independent. And I don't want to make a lot of that because I don't think it arises in this case. But for example, there are cases when, such as my Lord may remember the Trebor-Bassett case, where there was a question of whether or not a football club's logo appearing on shirts, which were then on football cards, was trademark use in relation to the cards in question. And one of the points made is that, in the line of authorities relating to that, is that the average consumer viewing that would not necessarily view that as use in relation to
Yes,
the
but
cards.
that's a different question.
It is a different
that's
question.
That's a question of contextual assessment of the sign.
Yes.
But your answer would be the same, regardless of whether the issue was infringement or genuine use.
Oh, on that point, my Lord, absolutely. The only difference one might say in relation to genuine use, which is why cases like Walton may not be so much on the radar of infringement, is because there is a further issue to be considered in the context of genuine use cases, namely whether such use as there has been is sufficiently substantial to establish a market and so forth, and that line of case law. In the case of infringement, there can be use by a single article, single object of commerce, to use a neutral term. In the case of non-use, it does not follow that the sale of a single article, which would be an infringement, is sufficient to establish the continued, because there's a further stage in the analysis. And I don't want to labour that point, but it's just to qualify, perhaps for the benefit of those who have not had to consider this particular issue in quite such detail on a frequent occasion, why I do so. But subject to that, That's absolutely correct. The place where context comes in, as my Lord Justice Arnold says, is in the evaluation of the mark, or the sign more strictly, used on or in relation to the defendant's goods, and what the average consumer takes from that mark or sign. Now, in the primary context, where that context is relevant, one is considering whether or not there is, for example, confusing similarity or similarity between mark and sign, having regard to the perceptions that an average consumer is deemed to bring to that encounter with the sign. In the context of targeting, in our submission, there is a similar question of context raised. One can put it in very colloquial terms of asking, is this mark or the product so marked for me or for this country? And I'm putting that in deliberately colloquial,
Is there
colloquial
anything
terms.
between you and Mr. Edinburgh on this question? Mr. Edinburgh doesn't say that there should be an contextual assessment. On the contrary, he relies vigorously on the context.
Yes, the only thing that it might be said is between us is that what my learned friend seems to be saying is that one needs to look at matters exclusively from what might be called the notionally subjective perspective of the average consumer. And when I say...
asked him about that, he said no. He said he accepted that it was an objective question. You view it from the perspective of the average consumer, but you take into account the entire context.
Yes, that's absolutely right. When I say notionally subjective, I don't mean in literally subjective. It's the perception that an average consumer brings to bear, and only the perception that an average consumer brings to bear. And as I understand it, just to be concrete about this, I had understood him to be saying that it is wrong in that kind of context of evaluation to take into account matters such as whether, for example, a site in question has in fact attracted eyeballs, if I may put it like that, from a particular territory, because notionally that may not be known to an average consumer, but it is, in my respectful submission, a factor which can be taken into account in deciding the ultimate question, which is whether notionally to the average consumer the relevant products would be regarded as being directed.
So you might say it's not targeted at Greenland because there's never been a Greenland person who's come on the site, and we've never thought of it. And even if Greenland is listed on the country's list, nobody's actually ever ticked the box. And that list of countries is always far too long because, irritatingly, they never put the United Kingdom at the top. They always put it at the bottom. Right. But it's all very well to speak in these general terms, Mr. Alexander, but it would help me if you gave me some headline points.
Yes.
As to why Mr. Edinburgh's main argument on use by way of advertising and use by way of
Offers
for sale is wrong.
Yes, I'm going to come on to that directly, because what I just want to do is do the law first of all, and then look at the...
You're sort of doing the law, but if I may say so in a rather mercurial way, and a bit too mercurial, maybe aimed at my Lord Justice Arnold, but there are three members of this court.
Yes, my lord, I apologise. I was on a lead-up point. The point is only this: that we respectfully submit that the core grounds for why, to answer my lord's question, are in the judgment, and the judge correctly evaluated the perspective that the average consumer would bring to the relevant advertisements and indeed offers for sale. And I will show my lord exactly what he did. My point is only to say that he was entitled to and did take account of matters such as my lord's Greenland point, which may not be regarded as something that would be known to a notional average consumer. And he was in making the evaluation as to whether there was targeting, appropriately taking that matter into account.
I mean, the problem for me, let me tell you right up front, Mr. Alexander, it being nearly 4 o'clock on the first day of this hearing, is that when you actually look at the Amazon.com website, so far from dissuading UK users, that there is every facility to allow them to buy. So you can go into pounds, you can say you've got an address in the UK and it pops up and says we can ship to the UK, and so to say that it's not used for the purpose of advertising to UK consumers seems strange from the perspective of a UK consumer, since the UK consumer may be told there's a .co.uk site, but I would think a vanishingly small number of such consumers needs to be told that. You know, when you make a Google search, you get Amazon.co.uk followed swiftly by Amazon.com. If you put just Amazon sneakers, you'll get the two.
Yes,
Now, how do you say that the judge can have come to the right conclusion when he's taking context, which is things like the number of people that actually do it, the extra cost that is incurred? I mean, from the point of view of the consumer, surely the actual content of the site is very important.
Oh, yes, my lord, and that's perhaps why I was making the points that I was. We don't say that it's not very important. Clearly, the actual content of the site, as it appears to a consumer, is very important. But we would respectfully submit that it is not irrelevant to consider how many people have actually gone on to the site and have gone on to interact with it in a particular way. And if I may say so, my lord, my lord's example of the Greenland situation is actually an interesting analytic one. Your lordship may say, well, it doesn't have application here, but it is interesting analytically for the following reason. Let's suppose that there is a Greenland drop-down and sales marked in whatever it would be, Danish kroner probably, bearing in mind the territory. You
haven't been to Greenland?
I'm afraid I haven't, but I understand that it's part of Danish territory, hence that point. One might say, well, look, although that appears there, and although exactly the same language may appear, or equivalent language, whether it be in Danish or in English, as appears in relation to the material that is available to the United Kingdom, the fact that this is not something that anyone has ever gone to is a relevant factor in considering whether or not that particular site, to use a generic term, is in fact targeted at Greenland. And our submission is that all matters of relevant context can be taken into account in evaluating whether or not a given online marketplace's offering, specifically with respect to a particular product, is or is not targeted at a particular territory.
I mean, I get all that, and if this case was about Greenland, I would perfectly see that the judge's balancing exercise would be a perfectly reasonable balancing exercise. Greenland only appears in a drop-down menu. Yes, it's in Danish and Danish kroner, but really there's not much more to show that it is targeted at Greenland. But the problem with this is that we have Union Jacks, we have the quite clear indication about VAT, we have do you want it in pounds, give us your address, we'll arrange shipping to the UK, and it all looks quite, if I may say, using colloquial language, targeted at the UK. Now, do you say, is your defence to this, well, the judge did this exercise, taking into account the correct factors, and it is not for this court, in the absence of perversity or showing that he took a wrong legal approach, to overturn it?
That is my primary submission in relation to the judge's evaluation. But the reason, my Lord may say I'm labouring this point in relation to what might be called the actual users of the site,
Yes.
is because if my Lords say, well, the only perspective that is relevant to be taken into consideration in deciding whether or not a particular offer is targeted at a given territory is the objective perception of the average consumer, and leaves out of account completely matters such as, well, no one's actually been on the website. Everyone goes to, let's say, the local website. My Lord's example, the Greenland website, if they are in Greenland, or the UK website in those circumstances. Then my learned friend, as I understand it, would say, well, effectively what happened was that the judge took into account factors that he shouldn't have taken into account in making the overall evaluation, and therefore that evaluation is susceptible of being overturned, because although it was a multifactorial evaluation, it was one that took wrong things into account. Now, in our submission, what the judge did, and this is why I was wanting to show my Lord the way in which he articulated the law,
By all means.
he recognised that this was a multifactorial evaluation that did not only require evaluation from, as it were, the eyeball on the screen, but could take account of other matters, including matters such as the subjective intention and so forth of the relevant operator, which ex hypothesi may not be known to the average consumer. And as a matter of evidential evaluation, it was not incorrect for the judge to take those matters into account, and having done the whole multifactorial evaluation, where he looked at all of the factors that my learned friend has drawn to your Lordship's attention, and he then looked at all of the factors that Mr. Miller drew to the court's attention, and came down to the evaluation of targeting as a whole, and we say that was correct.
Can I ask you another question?
Yes.
Then I'll promise to shut up. Average consumer. Is the average consumer that we are concerned with any consumer in the United Kingdom? Or is it any consumer in the United Kingdom interested in purchasing from overseas or the USA websites?
That, if I may say so, my Lord, raises an underlying and quite deep question in trademark law, namely, what are the characteristics of the average consumer?
Yes, I know, and it's also very relevant to other aspects of European law.
It is.
Yes.
And my Lord Justice Arnold has written with great learning on some of these aspects, as have others. The difficulty, as my Lords will, of course, appreciate, is that the average consumer, to use language developed by my Lord Justice Arnold, is a normative concept. It is a little bit like the reasonable, or perhaps normal.
Well, you've got to be careful with that. It has normative edges, to be sure, but the core of it is empirical, and that's the key point of debate on this issue, is the extent to which it has any empirical dimension at all. Because if you ask our colleagues on the continent, they would dispute what I've just said and say it's got zero empirical element. It's all normative. Whereas we don't and have not taken that view.
My Lord is of course right, and I should have made that qualification. It is inter alia a normative concept. It has been said in other cases that it is desirable for, I'm not sure I'm encapsulating exactly correctly, but it's desirable for the concept of the average consumer as closely to approximate reality as is possible.
Yes, but I mean, the question I asked you is whether it's the normal person who actually is at all interested in going beyond the borders or not, because there are two sorts of consumers. There are consumers who, when they see anything to do with US dollars and overseas or French or German or anything outside the UK, run a mile and immediately delete or turn off the computer and run away. Or there are people who are desperately looking for the odd things in life that they can get from a different country. And whether you're looking at one or the other may matter considerably. I think you're accepting that it's a normal UK consumer.
Yes.
Average, normal UK consumer without preconceptions.
Yes, I think I do. I can't immediately think of any authority which has specifically addressed the question of what might be called the foreign interest characteristics of the notional average consumer. But my lord is going to correct me on that. I'm quite certain.
That was front and centre in Walton, because the whole point in Walton was that the people who went to the claimants' websites were people who had encountered their goods abroad. They were a special class of consumers. That was what it was all about.
So what was the goods? I'm sorry to ask, Mike.
The goods were clothing, both sold under the trademark Giordano, I think.
So you had two rival groups of companies, and the claimants were primarily operating in Asia, Australasia, and a few other countries, whereas the defendants were primarily operating in Europe. And there was the evidence that the claimants were particularly relying upon was all derived from consumers who were, at the relevant time of the trap purchases, based in the UK, but they had all previously worked abroad, and that was where they had encountered the claimant's trademark.
Yes, and my lord analysed a number of the specific responses, because unlike the present case, where there was no actual evidence, I think I'm right, of actual consumers encountering the mark in question, in that case there was evidence from, I think, as many as 6 or 8 actual consumers who were cross-examined and who made each observations of a subtly different kind as to what their perceptions were of the extent or otherwise to which they regarded the goods as being targeted at them. And I've tried to summarise the matter. That may not quite accurately summarise it, but that's my recollection of it. What my lord is of course right to say is that there was a particular factor in that case, namely that these consumers were in some senses foreign primed, or at least the notional average consumer was foreign primed by circumstances relating to the particular trade.
I mean, the problem here is that there are two sorts of average UK consumers of the kind I mentioned. One, people who may buy things from overseas sometimes if they're at the right price or in the right of the right type, and those that don't. I mean, let me give you an example. I happen to be quite a small person. If I ever go to the United States and buy clothes, I can't get clothes that fit me because they don't make clothes for a person my size. But if I go to the Far East, I can buy lots of clothes because they're all made for people my size. Now, I don't, but I might go on Asian websites to buy clothes because they come in the right sizes for me. Now, when you're asking what the average consumer is, there may be lots of big people in the United Kingdom who would like the larger sizes that are made in clothing in the United States. And that's not a stupid idea.
No, it's far from a stupid idea, my lord. The only point is that, unlike in the Walton case, there wasn't evidence from either a specific category of consumers that my lord has identified, looking for particular kinds of goods.
So the judge was doing it on the basis of the average consumer, full stop.
The judge had to do his best on the basis of the material with which he was presented. Now, that is not an atypical situation in trademarks law, as my lord will know. The question of whether or not there is, for example, confusing similarity is very frequently addressed by tribunals on the basis of no actual evidence of any actual consumer being confused, or not confused, as the case may be. And we would respectfully submit that a question of targeting, which is another one of the multifactorial assessments that courts are called upon to make in this sphere, would equally not typically be done by having actual consumers, as it were, traipsing through the courtroom, saying, oh, I thought that was directed at me, or I didn't think it was directed at me. But there are some factors which we would respectfully submit every consumer, whatever their kind, might take into account. One of which the judge mentioned, was, for example, where a particular website comes up in a search ranking. So, if you just type in a particular mark, because there is a range of different undertakings or different websites which are directed at different territories, but which may come up on a search ranking, one might say that the notional average consumer concerned with internet shopping and so forth is much more likely, when they look at that, to say, okay, well, there's the UK one, for example, that's come up. That's the one for me. It's come up first when I do my search. I see, of course, that there is in this case, Amazon.com. I may see that there is an Amazon. I don't know, IO, let's take a topical, Indian Ocean, or whatever, down the rankings. And if I click on that, I may get that website, and I may get particular characteristics in relation to that. But it wouldn't follow that I would think that that was for me. Now, in our respectful submission, a court making an evaluation of whether a particular site or online marketplace is targeted at a given territory can legitimately take account of all of those factors. And the reason why it is legitimate is because those are things that an average consumer is actually likely to take account of when they're looking at a, let's say, a search page or whatever it is.
This is where Mr. Edinburgh says that the word targeting is incredibly confusing. And as I understood, when you ask the question, is the website Amazon.com targeted at me, then you immediately get into the thought of whether somebody is directing it at you deliberately, not to the correct question of whether the sign on the website is being used to advertise that product to you in the territory.
Yes, your lordship is of course absolutely right, but let's suppose you get through all of this, so you've got on to Amazon.com and the documents that my lords were shown, and you see, as I think one of my lords indicated during argument, oh, this is something that's denominated in dollars on the Amazon.com website. Even though it may be that you could do a currency conversion later on,
But it's
we're
not
down
right,
in the transaction.
That's not what it is. It's saying, do you want it in a different currency? Please tell us.
I mean, the judge, as well as targeting, the judge described the test as being whether the website, i.e. the Office for Sale and Advertisements, are designed to attract sales from the territory in which the relevant trademark is registered. If you ask the question, is this site designed to attract sales from the UK? What you're going to have to answer tomorrow, I suspect, is how can it be a valid conclusion that a website that offers to deliver goods to the United Kingdom, offers to allow you to shop in different currencies, deals with estimated import fees, asks when you want it delivered, describes it as being shipped to the UK and delivered to the UK, can be said not to be designed to attract sales from the UK?
Well, my lord, I understand that point, and the short answer, and I'll try and give a better one in the morning, is that there is a distinction that one might make between what might be called passive presence and availability online and active targeting of a given territory. And my lord...
But in a sense, what this doesn't say is, if you're accessing this site from the UK, don't look here. It sort of bypasses all the questions about how big you are, what your favourite currency is. It offers you all those possibilities and says, we'll ship to you if you want.
My lord is
as opposed to just saying, if you're from the UK, you shouldn't be here.
Yes, my lord is asking the question, is it making it, in a sense, too easy, if I may put it like that, for a customer in the UK to continue with the transaction in that context, rather than going to the site that is in fact for them, namely the .co.uk site, to which their attention is in fact drawn. And my lord has seen the way in which it is drawn. And we would respectfully submit that one needs to look at an overall factual evaluation. One needs to think, okay, well, the mere fact that it is making it easy to that extent, or was making it easy to that extent to do that, even though obviously now there are relevant blocks, doesn't mean that there is targeting at the UK or an intention to attract sales from the UK. Or at least not a sufficiently specific
You make it very
intention
easy.
in that respect.
I mean, the issue is the website seems to make it, in fact, very easy to have sales to the UK. It offers all the facilities that you'd need if you wanted to buy these products from the UK.
Well,
you're right, it gives you an alternative in a little strapline on the front page. But once you've either missed that or decided not to go with it for whatever reason, then how could it be said that it's not designed to actually sell you something?
yes, I mean, it certainly makes it possible for you to buy it through the website. The question is whether it
sell
is.
you it. Why wouldn't they want to
Mr.
sell
Alexander,
it is so designed.
I think that at 4:15
Sorry.
we have given you your homework.
You certainly have, my lords.
You can go and spend a pleasant evening doing your homework, and we will return to market in the morning, and we'll resume at 10:30. But there's no danger of
Oh no,
time.
no. I hope to finish easily before lunch.
I'm not going to hold you to
Famous last words.
10:30.